My lord, may I be permitted to mention one bail in connection with appeal?
After 15th, after
My lord, on September it was mentioned your lordship was pleased to allow it, but till date it has not come up in the supplementary list, my lord. Some
after
problem with
15th mention.
grateful, my lord.
My lord, this is that matter, my lord, that Elita matter. It was supposed to be, my lord, lordship had indicated yesterday. So yesterday it was.
Next week we will keep a date from next week for the part-heard assigned matters.
Lordship.
Maybe Thursday or Friday, first half.
Malad, may I permit?
Grateful.
Malad, may I permit to mention, Malad?
One
My lord,
second.
one matter, Malad, regarding habeas corpus.
Yes, mention.
Malad,
Oh.
one matter regarding habeas corpus. Regarding determination of Malad, Justice Malad, Arjit Ganguly Malad.
Yes,
Or is
just
Banerjee Malad. Urgency is that Malad, the lady Malad is Malad, minor Malad. He's missing last 3 months Malad.
give you a slip.
Yes, Malad. I will see. Develop.
For bail, my lord, file in 29.
Item 1. In the case number, it is written as 2023.
Necessary correction. Next.
Item 2.
Correction. Same order.
Yes, yes. Item 3. Everything on behalf of matter of 2020 probably had to be 1 day time.
Monday. Monday?
Item number 4, my lord, I appear on behalf of the petitioner.
Yes.
But 4 and 5, my lord, I appear for the petitioner, my lord. The
Right.
allegations. Under Sec 471, 42, 473, 341, 323, 254B of IBC and my lord 31R and 31S of SC/ST Atrocity Act. My lord, kindly see the letter of complaint once more.
Yes.
Senior fight that please.
Page 18, my lord, is the letter of complaint. This is out and out a money claim, my lord.
বাউন্স করেছে তাদের ফ্যামিলি মেম্বার্স তারা বিজনেস করতো তাদের প্রপার্টারশিপ ফর্ম
Victim be added as a party. De facto complainant victim be added as a party.
My lord, I'm appearing for the de facto complaint.
You are appearing for the.
Yes, my lord.
What do you say?
My lord, the whole transaction means the prime accused is the petitioner in item number 6.
Oh.
Prime accused. And all the family members were running an entity. I have enlistment by name Smart Choice. And on the name of that, they have represented that they have been entrusted or they are they have the license from RBI and they have defalcated the money or transaction almost about 40 lakhs, 20 lakhs from a single family or members.
Then That's a commercial transaction. It's not a chit fund business. There are no multiple depositors in this case.
There, the two hours before your lordship.
There are two people. How many people have invested here? There is a difference between multiple investment by disparate individuals. And if two members of the family invest 40 lakhs in a company, that's a commercial transaction.
It is under the investigation.
Yes, that's true. Take down. Petitioner contends that the de facto complainant had invested money in the company. Crux of the allegation relate to failure to refund the deposit. He further contends that the allegations Monday. Grateful. Or allegations do not disclose the ingredients of the offences punishable under the Scheduled Caste and Scheduled Tribes Prevention of Offenders Act. State shall submit report whether the alleged deposits, whether deposits to the company is restricted to the complainants or it relates to multiple individuals. A report shall be filed on the adjourned date. Matter will appear 1 week hence. Both the matters. 14. Next. 6. 6. 4 or 5. 6.
It's the same matter.
Similar matter, my lord.
The prime accused is before your lordship.
Then what is 4?
There are two FIRs.
1 second.
Yes.
4 ta ki hai?
My lord, here, my lord, SCST Atrocity Act is not there, my lord, and I have taken, my lord, their claim is 22 lakhs. I have given the bank statement wherefrom it reveals that I have returned already 53 lakhs, my lord. 53 lakhs, my lord, I have, my lord, repaid.
4.
No, sir.
You are in 4.
I'm in 4 and 6.
4 and 6.
And 6 for the de facto complaint.
Okay. And 5?
4 and 5 because the father and
Son and the daughter. So 4, 5, 6 same cases.
6 is another FIR. The same matter, but another FIR.
Are you appearing in 6?
Yes, my lord. For de facto.
So he's another family member.
Yes.
So 4 is father, brother. 5 is father and daughter, and 6 is who?
6. The
Who is the depositor?
depositor is Nirmal Patro.
How is he connected with the depositors in 4 and 5?
He is not connected with.
He is not connected.
He has deposited individually.
Individual. Find out how many other depositors are there.
Yes, ma'am.
All right. Same order in 4, 5, 6. না 4 এ ওটা দেবে 5 আর 6 এ বলবে list along with 4. In 5 and 6 there is no Scheduled Caste Act, right?
4 there is scheduled caste.
But in 6 it is not that. তাহলে 4 আর 5 এ same order, 6 will be tagged with 4 and 5. Right. Please find out how many.
6 is, my lord, are different, my lord, out of a defense.
The wife of the de facto, she belongs from the scheduled caste.
We have seen it. We've seen the allegation. We have asked whether in 5 also the same allegation is there. So the complainant is to be notified. In 6, the complainant is appearing, but it does not relate to scheduled caste and tribe. But he is a different depositor.
Yes, ma'am.
So we have to find out what is the quantum of deposit of this nature. Right? Ask your police to make that inquiry and give a report to us. Next matter.
7.
Appearing almost after a year to the
Not today.
Eight.
8. Not today.
No.
9.
Make pleasure, loss. But this case is under 467, 468, 471, 409, 420, 379, and 34 of the Indian Penal. The complainant is the director of a company called Shahi Construction Private Limited. In 2019, he came to be acquainted with the petition. He appointed the petitioner as the chief financial officer of his company. It is alleged that in 2023, under the advice of the petitioner, the complainant's company sold leather items both in domestic market and also to the foreign buyers. The amount with regard to the sale was 14 crores 56 lakh 91,634. So for the foreign buyers are concerned, as per the allegation, the complainant's company did not receive any payment. This is one part of the allegation. Other part of the allegation is that the goods were sold in the domestic market. So on this plot, there is that approximately 20 lakhs of rupees, the petitioner has approximately 14 crores 56 lakh 91,634 rupees, they have suffered the financial loss. Now, you will kindly turn to the order passed by the coordinate bench.
Yes, you have to meet the investigating officer.
Yeah,
You have to meet the investigating
that
officer.
we have done on 3 occasions. I have made the investigating officer. I have also not produced all the documents.
Place the report before your lord.
It was copy for our. No, there was a type of compliance.
But notices have been sent to all the overseas companies. There has been no reply from them. So far as the two shipping lines are concerned, one was found to be that of the brothers of the petitioner, and the other shipping company we have already sent notice, but there is no reply. Whereas the funds were routed through all the shell companies. One person was arrested, namely Ansar Mondol. Although it's a statement of co-accused, but he admitted that he used to prepare fake GST bills for the petitioner.
Petitioner or the company? Who is the person liable for GST?
Company.
Then who is liable for GST? Who is liable for the sale or purported sale to official to overseas buyers? If these are fictitious transactions, the transfers, they may be hawala transactions for the company. The transactions take place between 2019 to 23. The company does not have any accounting process. There is no audit of the company. There is no annual returns filed by the company. How long the dues are outstanding? What steps have been taken by the company with regard to the dues which have accumulated for the last 4 years? These are matters to be investigated. Yes, Mr. Adul.
I'm appealing for the de facto complaint.
Right.
But he was in complete control of the company.
Everyone is. What is your background, Mr. Edulji? How long are your client carrying on business? Complete control. You want to evade your liabilities and now you throw the blame on the employee. 4 years your company has so-called transactions with foreign dealers and you do not take any steps with regard to non-payment, and today suddenly you wake up against an employee and start criminal case.
He was never an employee. He was a commission agent.
Okay, whoever.
Marat, for example, Marat,
All right, take down.
may I just take 1 minute?
Yes.
Marat, what he used to do was, there were bills of exchange. Now what he has done is, he used to discount the bills of exchange. Now after discounting the bills of exchange, he has removed the money into his private account. Then we were told by the bank that they were dishonored, and hence we also had to pay back the money from our company. Marat, I've given a written notes of arguments to lordship. Just see, Marat, that we have received the entire payment. Entire payment.
So yes, where is the written notes of argument?
Because
I have also filed a short note, Malad. It's there on the record, Malad.
are you denying it that you have received the payment from both banks? জানো যে চারটি ব্যাংক ওদের পুরো টাকাটা ফরেন বায়ার্স দিয়েছে, it has been credited to the account of the default complainant. রিট পিটিশন ফাইল করেছিল, রিট পিটিশনে কি অর্ডার হয়েছিল দেখো তো, পুলিশকে রিপোর্ট দিয়েছিল।
in নাম চারটে ব্যাংকের will confirm that he has received the entire payments. এইটা না মেসেজ মার্ক করা আছে।
Have you got the notes here?
Yes.
Copy?
Yes.
Come to paragraph 2.
The filed by the de facto complainant? No, my lord, I don't have it.
Give a copy to him.
No, the entire amount has been credited to the account of the de facto complainant.
Mr. Basu, we need to get the responses with regard to the issues. So, do you have a copy of the?
No. No copy has been served upon us.
What is the practice? Never seen this practice, Mr. Idulji. You claim to be, aspire to be a senior counsel.
Two written notes.
You don't have the practice to request, tell your advocate on record to give copies before you submit it before the court. It's never a correct practice. Copy of this document has been served upon the parties. The notes that you have filed.
Last question, sir.
No. You've got it, Mr. Idulji?
Okay, diye আমাকে তো দিস নি।
What's the hearing this?
We have not been served with it.
If you have not got it, just circulate the copies. Otherwise, how the submissions will be understood? Mr. Basu, what we want is this report, please give it to them. There are certain issues raised in the written argument with regard to some of the companies. The sale, they say that they are fictitious. Now the police, you have submitted some documents to the police which show that they are not fictitious, right? So do they relate to these companies? Because the report of the police is cryptic. We don't know whether the names of the companies reflected here are the companies which, in respect of which you have given documents. Secondly, is another allegation with regard to a bill of exchange of 24,000 euros. What is your response to that? Right? We are keeping this on Tuesday.
Tuesday. আজকে বুধবার না বৃহস্পতিবার?
আজকে it's a Friday. Friday.
Mr. Sengupta will require your response on these documents. These, Mr. Idulji, is your client's grievances, right?
Whether the list of the companies submitted by the petitioner?
We don't know. Please go through it. There, please see paragraph 2. He says that these are the companies which are non-existent.
I can always
What documents has he filed? Does it relate to the existence of the company? Are these companies with which the complainant company has had a long time standing trading relationship? Correct. These are things we want to know. And the other allegation that he had dishonestly discounted a bill of exchange and transferred the funds to his own account. That is, we need the response in respect of that. Right? With regard to the foreign buyers, we have seen it. Any further submissions, Mr. Edulji and Mr. Sengupta, we will see. Tuesday.
So the interim protection may be extended.
Yes, it is there.
No, it
There
is
is.
till 11.
Up to,
Somewhat good.
Somewhat up to 11 it is.
30th of November.
Interim protection is extended up to 30th of November.
Item 10.
Russia, I am for the petitioner. Allegations are, my lord, 326, 354, 308, 379. My lord, dispute arose over the issue of landed property.
Slight and moderate.
We have considered the materials on record. Injury report does not disclose grievous injury. In this backdrop, custodial interrogation for progress of investigation is not necessary. We are inclined to grant.
Affidavit of service, Lordship, kept.
Every service placed on record, nobody appeals for the defect. Next.
Rule 11, my lord, I am appealing virtually, my lord.
Yes.
My lord, special would be to kindly come to page 51 first. This is my letter of appointment, my letter of intent subject to my lord, I was granted interim protection by this honorable court on 7th. And I was asked to be called, but nobody called me. My lord, page 51 is my letter of joining. This is where I give my letter of intent. Thereafter, my lord, I leave this company from 2017 to 2021. I'm a part of the company to 2021, 26 I'm made to resign. Your lordship would kindly see page 52. Kindly see page 52 right in between. This is where a declaration has been given by them through mail indicating that there is nothing to be received by me. Page 52. Right in between. Saw you're working. There's nothing to be received or given to you. You have not worked for 5 years. Gratuity is not eligible. Just give a proper handover by giving audit and legal handover to be given. Then, my lord, there are correspondences which continue between this is happening to 2021, 2022. My lord, sees page 54. This is again coming from the person concerned. Right in between, Umang UD to Vinay Jain. Confirming I do not require any money from you. Come meet me personally. We will discuss what issue you have. Thereafter, my lord, a complaint is lodged against me, which is there in page 60.
Yes.
Which is dated 7/3/2022. Your lordship would see that this results in Raniganj PS case number 122 of 22. Well, this is the summum bonum of the allegation that I have taken 45 lakhs and I'm not repaying them. And I am extorting money by vilifying the reputation, which is there. Malad, thereafter, I was granted anticipatory bail. Malad, I was granted anticipatory bail. Thereafter, charge sheet was filed in this matter.
This is not the case where you are asking.
No. Thereafter, Malad, after the High Court granted anticipatory bail to me. Thereafter, charge sheet was filed. Thereafter, I went behind him because I knew all his dark secrets. I went behind him, which is there, which all are there, my lord, from page 71 onwards. I start complaining to GST and I start complaining to IT. income tax departments, indicating the mode and manner in which this company was operating. Because they continued to go behind me, and I went and I clearly told them what it is. This resulted in the second complaint.
Where is the second complaint?
Malad, page 30. I'm sorry, Malad, it starts from page 21. Almost identical allegation with regards to the first one, save and accept me demanding 50 lakhs from him as an extortion money. Malad, the first round of litigation, extortion allegations were dropped in charge sheet. Now, Malad, while I was cooperating, the 41A notices, Malad, my phones were seized.
Yes, what do you say?
If your lordship desires to see from, I've not only attended from page 32 onwards,
Petitioner submits that he was working as a manager. He was working as
accountant.
a manager, accounts and finance in the complainant company. He resigned from the complainant company in 2000. He sent a letter of resignation to the complainant company in 2000. In response to the resignation letter, the owner responded that he did not require money from owner responded to he offered to resign. Subsequently, a criminal case was registered against him in 2022, alleging that he had wrongfully refused to repay a sum of rupees 45 lakhs.
50,000.
It's 4 lakh.
4 lakh 50.
4 lakh 50,000 to the company. Thereafter, he had made complaints with the DRI, with the Director General of Goods and Services Tax Intelligence and Income Tax Department against the company. In retaliation, the present case has been started for anticipatory bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Petitioner had offered to resign from the company in 2021. Thereafter, a FIR was registered against him, alleging he had taken a loan of 4,50,000, which he had refused to repay. He was granted anticipatory bail. Subsequently, another FIR a present case has been registered, alleging that he demanded 50 lakhs from the company. Full stop. In the interregnum, petitioner had lodged complaints with the tax authorities, alleging tax evasion by the company, possibility of false implication on this score cannot be ruled out. In such view of the matter, we are of the opinion custodial interrogation of the petitioner is not necessary, and he may be granted anticipatory bail subject to conditions. Meet investigating officer once in a week or further. What he is saying is, now after complaining, he is saying
For the petition.
Lordship, I'm for the state.
So I am for the state.
Order হচ্ছে না। না তুই
So one petitioner is not there. 164 of the
Not today.
not today.
He has not come. 15.
Yes, man. Can fix them on Tuesday.
Why? Tuesday. What you will do in Monday?
Monday.
302. Man.
Initially, case started on the season 363.
363.
302.
Subsequently, dead body of the boy was recovered.
Okay.
I'm grateful. Monday, my lord.
Monday.
Your Lordship, may I just mention one thing for item number 11? Your Lordship had directed the petitioner to meet IO once a week. He works in Guwahati, Your Lordship, and the cases of Asansol Bardwan. Can it be the condition that whenever he is called by the IO, he will attend, Your Lordship?
We'll recall the order. Let us recall the order.
No, Your Lordship.
Please do not mention after an order is passed who gives you the liberty to come in and butt and say this.
Apologies. Apologies, Your Lordship.
I'm for the state. 16. Just now I have received the case diary.
So what?
Case of my lord 420, my lord. My name has been transferred on the co-accused statement, my lord. Some person, my lord, arrested before the medical college, front of medical college, my lord. Thereafter, my lord,
You are selling blood.
my lord.
Then
They are touts, my lord, arrested.
we
my
are
lord. Subsequently,
considered the
my name
materials
has been
on
transferred,
record.
my lord.
Allegations involve illegal selling of blood, human blood. Involvement of the petitioner has transpired during investigation. Custodial interrogation, his custodial interrogation for unraveling the conspiracy, unraveling the organized crime network in dealing in human blood is necessary. Keeping in mind these facts, we are not inclined to grant and suit review. Next.
17.
17, I'm for the petitioner, my lord.
I'm for the de facto complaint.
Seeking bail on anticipatory bail on parity, my lord. Most of the accused persons have
Same
been granted
footing.
anticipatory bail.
Petitioner contents co-accused have been granted pre-arrest bail. He stands on the same footing
Lordship,
with the petitioner. Accordingly, we are inclined to extend the same privilege.
He
Lordship,
happens to be the partner of the company which has received 4.5 lakhs. The complainant was induced by one Piyush Mantri, he is absconding.
No, but he was granted bail on
No, Your
surrender.
Lordship, this is a wrong submission that has been done on previous occasions also. Piyush Mantri is absconding. He is not available or he has not been taken into custody.
No, Piyush Mantri is on bail.
My lord.
No, Your Lordship, he is not on bail. He is absconding.
Can we call for the record because last day I produced certified copy of the orders. That
No,
was
Your
placed in
Lordship, he is absconding.
My lord, he is chasing Piyush Mantri, he's not been apprehended till date.
He is saying he is on bail.
Well, last day certified copy of the order was produced.
Has he not been arrested in this case?
He is
Well,
absconding.
certified copy of the bail order was produced and he was,
You
this was
just give a
considered.
report, huh?
My lord.
Grateful.
My lord.
When should we keep it?
On a Tuesday.
Tuesday.
Grateful.
How can a man be on bail and you?
18 my lord, similar prayer because it's
17, 18
same
Tuesday.
FIR. Diploma.
17, 18.
For the petition, may it please the Lordship. Well, 135, 138 of the Electricity Act, there is a
Yes,
there is a
we want the bill for unmetered consumption.
my lord. The problem
Give notice. Ask Aniket Mitra to appear. Monday.
Monday.
Please ask Aniket to appear.
My lord, service is not complete to the VC. My lord, although
For the state lord.
20 service is not complete, my lord.
What is
Three
this?
sisters were kidnapped.
My lord, my lord, I submit. Co-accused granted bail. The principal accused granted bail by this honorable court by coordinate bench. One thing, my lord, I am submitting one thing. The major sister lived with her two minor sister on Khairul Mullah. On Khairul Mullah, he's got bail from the
All
coordinate
right.
bench.
All right. Copy of the petition. Officer in charge shall notify the victims with regard to pendency of their right to legal representation Thursday.
Service not.
Is your service? Have you served the victim? No,
Service, not
you have not served the
the
victim.
service. I served the victim, but not
Not complete.
21 and 22.
Wait, please, Your Lordship. I'm appearing for the petitioner.
We beg to appear on behalf of the de facto complaint. Last occasion, the matter was taken up by your lordship. Just I am, my lord, subject to lordship, my senior friend sanction. Last occasion, my lord, that time they have submitted that another application for anticipatory bail is pending. That was, my lord, tagged together and come to today.
Very good. May I comment? My Lord, if Your Lordship kindly takes up 22 first, this was a matter which was pending before Your Lordship. My Lord, this was a case under section 302 in which an interim order was initially passed. If Your Lordship is kind enough to take up the order dated 8th of October, which was passed by this honorable court by a coordinate bench. Granting me interim protection in view of the fact that there was no materials. If Your Lordship kindly sees paragraph 4.
Yes.
My Lord, I was not there even on the second occasion, but I was informed that the case diary was produced wherein certain statements were shown which contained his name, but they were recorded subsequent to the order passed by this honorable court, and therefore Your Lordship was not adjourned the matter because contention was raised that there are other cases against him. My Lord, so far as I could understand from as per instructions, there are 3 cases. So one is this one, the other is the item number 21, and in another matter which is Kaliachok PS case number 555 of 2023, he has Manikchok, I'm sorry. Manikchok PS case number 555 of 2023. He has been granted anticipatory bail by the Learned Sessions Court. So far as this is concerned, allegation is that on 15th of September 2024, the victim was shot dead in a local market. As per the instructions, I would use the word as in the FIR Poramorse. The FIR is at page 17, if your lordships are kind enough to see it.
On the advice.
Yes, it is Poramorse. Yes, on the advice, yes. But as the case diary at that point of time, on 8th of October, revealed that there was nothing which reflects that the statement of the eyewitnesses named the person as...
Cannot be eyewitnesses name because
I understand.
FIR is Poramorse.
Poramorse.
It's more like a conspiracy.
Yes, but kindly sees what is the nature of the evidence reflecting even prior concert of minds. Well, I am the Onchol Shawapati of the local area, and that is why I am being implicated in different cases due to the political reason, as my wife is also the elected Onchol Pradhan of the local village. Now, the purpose is to put me under pressure and maybe gain some advantage politically.
You are accused number?
I am accused number 1.
You are Nasir. So
Mohammad Nasir.
So in the FIR it says that হইয়া মার্ডার করিয়াছে এবং 1-2 নম্বর আসামি মানিকচক থানার 270-18 এবং
Yes.
4 নম্বর আসামির বিরুদ্ধে
4 is not before your lordship. Humayun Sheikh is not before your lordship.
No, you are in Manikchok 270 accused.
Yes.
And
Yes.
Humayun is accused.
I was in custody for about 60 days and thereafter I was granted bail in this case in 2018.
Is Manikchok 270 related anyway with the victim who was murdered?
Well, so far as my instructions go, no.
No. Independent act.
Independent act.
2018
Manikchok 270 of 2008.
What is the
My lord,
offense?
so far, subject to correction.
We have not asked you anything. What is the offense in Manikchok 270?
304.
304. Okay.
2018 কেসটা.
You are on bail in that case.
Yes, my lord, I'm on bail.
And the other case, what is the allegation?
My lord, in this case also, the allegation is against 59 people. I am also implicated as the accused number 1 there. This takes place on the 9th of June 2024. Allegation is that while the victim, that is the son of the...
They were assaulted.
He was assaulted and he thereafter succumbed. Now, 2 persons, namely Sheikh Israel and Estab Ali, they have been granted pre-arrest bail by this honorable court. That order is at page... My lord, it's annexed just after the FIR, which was annexed. 5, 6, 7, 8, 9, I gather, my lord.
Okay. 9.
Mohammad Nasiruddin, who is the accused number 2, his prayer for bail was rejected, and
Nasiruddin is here also Nasir.
No, Nasiruddin and Nasir are 2 different persons, my lord. One is Nasir, Mohammad Nasir, and number 2 is Nasiruddin.
Okay.
Also in the other case also.
Nasiruddin is
accused number 2.
In the
in this case also, in 22 also.
Oh, Muhammad Nasir and Nasiruddin. So Nasiruddin, you are in the same footing as Nasiruddin.
Well, in my case is that there may not be anything against me. Kindly seize the statements of the eyewitnesses. Kindly seize the date of the recordings, Miller. 21.
Statement of one of the person who was along with the deceased that he managed to clear. Page 18. He took name of Nasir.
He took name of Nasiruddin also.
Yes.
This is Your 690, Manichok 690.
No, 406.
406. That is the second case.
Yes. The first one, 21.
406. Now, these statements were recorded during the pendency of this application. That is your claim.
Well, kindly sees the date of the recording, whether they're even proximate to the time of the incident.
In an anticipatory bail
No,
application.
that happened in the other case, 22. When on 8th of October, my name did not transpire in the statements. When it came up before your lordship after the vacation,
Okay.
the statements reflected my name.
Now, let us take 406 first. But petitioner contends that he is the, you are
I am the Onchol Shabapati.
present sitting.
Yes, madam.
Petitioner is the Onchol Sabapati of the Gram Panchayat. He has been falsely implicated in the case.
Oh, my lord, it's only of the Onchol Shabapati of the political party.
Onchol Sabapati of a political party. Owing to political affiliation, petitioner has been falsely implicated in a series of cases. The allegation against him are general and omnibus. Co-accused have been granted bail in CRM A 2594 of 2024. Accordingly, he prays anticipatory bail. Accordingly, he prays for anticipatory bail. Learned lawyer for the state and de facto complainant oppose the prayer. They submit petitioner has criminal antecedents and prayer for anticipatory bail of Sheikh Nasiruddin was turned down by this court. Petitioner stands on same footing with the said accused. We have considered the materials on record. Petitioner is a political personality. A number of criminal cases is pending against him. One of such case was registered in 2018, alleging culpable homicide. He was arrested in the said case. Presently, he is absconding in a number of cases. Statements of witnesses recorded under 164 CRPC disclose him as one of the members of the Unlawful Assembly who had assaulted the victim, resulting in his death. He stands on the same footing with co-accused Nasiruddin, whose prayer for anticipatory bail has been turned down. He does not stand on the same footing with the other co-accused who have been granted anticipatory bail. Accordingly, we are not...
May I only humbly pray, if your lordship kindly sees the earlier order, it says that there is no specific role. Well, kindly considers whether any
Nasiruddin and you stand on the same footing, Mr.
There is an allegation of assault by me.
Nasiruddin also member of the group. They were not named in the 164, right? Rejected. Next, petitioner petitioner submit that he is the Onchol Pradhan of a political party. He was not present at the place of occurrence. He has been falsely implicated in a number of cases owing to political affiliation. He was not present in the place of occurrence. He has been he prays for anticipatory bail. Present place of occurrence during the pendency of the application, statements of witnesses were recorded before magistrate. In order to implicate him, he prays for anticipatory bail. Learned lawyer for the state and de facto complainant oppose the prayer. They submit petitioner has number of criminal cases. He is the ringleader, and on his instruction, the victim was murdered. We have considered the materials on record. Petitioner has criminal antecedents. He was implicated in a case involving culpable homicide in 2018. He was presently he is absconding in a number of cases. He presently absconding. He is implicated in presently a number of cases have been has also been lodged against him for murder of for murder. Two cases for murder, na? These two cases.
3, I have been granted anticipatory bail.
All right. 3 cases were lodged against him for murder. In the present case, it is alleged that petitioner has instructed his associates to commit the murder.
And who fired?
But in the FIR, it is under his instruction. All right. So which we will believe? Tell me. You are a prosecutor, which you will prosecute, which will be your stance. And the FIR is of an eyewitness.
Well, then this statement was perhaps not produced on the 8th of October.
That we don't.
There's nothing to reflect that.
Acha, prosecution contends that the FIR was not registered by a eyewitness, contends that statement of witnesses before magistrate show that petitioner had fired at the victim, resulting in his death. In view of the aforesaid incriminating material on record and gravity of offense, we are not inclined to grant that.
As it pleases you.
Huh? এটা হচ্ছে 3660 রোড লাস্ট এটা লাস্ট yes next matter
Eight seconds. 8 seconds with fraction of a second.
yeah. Absolutely. Next.
Lordship, I am appealing for the petition. Lordship,
For the defect of complaint.
498, 406, 313, Lordship. Now I gather they want to live together.
Petitioners have amicably resolved their matrimonial dispute and wish to live together as husband and wife. In view of the aforesaid development, we are of the opinion no worthwhile purpose will be served in committing the petitioner to custody and suitable. Next.
Grateful, Lordship.
For the petition.
For 24, I will just pray for a day.
Then
The basis of case study.
you'll not just kindly fix it on
24.
Tuesday.
Tuesday.
Monday, Tuesday.
Next.
25.
My lord, 6 petitioner before your lordship. Six petitioner, my lord, before your lordship. So far, charges as per the old provision, my lord, 307, 436, and 353. Others, so many sections.
How 307?
Yes. And my lord, they.
307, 109.
My lord,
109. What is 189 to?
189 to, my lord.
That is
unlawful
141,
unlawful, yes.
That should have been 190, not 189 to. 190.
190.
Why 189 2 is the definition?
190, 141 and 143. Whole section. So 141 the definition and 143 punishment. And so far, my lord, 130 to 188.
222.
222 is the uh, there is no 222, my lord.
223.
223 is there. 188.
188.
These
These are all forgeries.
326F, 323, all section.
These are trespass.
Yes, my lord. 323. Right. That's what.
320 is 115. 115.
115 subsection 2, 323.
Chalo. Whenever you move, first write down what are
Yes,
the.
my lord.
You are not right. You are not
No, I have
making the no. You are not making right submissions.
Yes, my lord.
You are not ready.
My lord, 150.
We have considered what is the any injury. We have considered the materials on record. Petitioners are the members of a political party. They have been falsely implicated. Allegation against them are general and omnibus. Under such circumstances, we are
the police personnel.
that advocate na everything advocate allowed. Next.
Twenty-seven.
Twenty-eight. I'm appealing. So far, my lord, main allegation so far old section is 436. And these petitioner all are my lord active member of opposition party. My lord, they protested so far, my lord, for the peaceful protection, protested for the Argical Medical College, and they have been assaulted, and subsequently this case has been started against.
Say the supporters of a political party, they started demonstration in front of the PS.
Petitioner submits.
Set fire on tires, shouted slogans by microphone.
Petitioner submit that they are members of a political party. They have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the state opposes the prayer. We have considered the materials on record, keeping in mind the facts and circumstances of the case. We are of the opinion custodial interrogation not necessary and petitioners may be granted answer.
Yes.
Well, I'm holding the brief of Shoumujit Dash Mahapatra advocate. He is unwell. 498, 489A, B, C, 2034 of the Indian Penal Code. Lordship, 8 person was arrested with forged note and some fake gold biscuit. They were arrested, Lordship. From their statement of the co-accused, this petitioner's name appeared, except statement, charge sheet submitted, all such, everything is complete.
Petitioner submit that he is no way connected with the crime. His complicity has transpired from statement of co-accused, which is inadmissible in evidence. He prays for bail. Learned lawyer for the state oppose the prayer. We have considered the materials on record. No legally admissible evidence connecting the petitioner with the crime has been collected. Under such investigation is complete. Under such circumstances, we are inclined to grant bail.
I'm high look.
Next.
Item number 30. I'm for the petitioner, my lord. My lord, out of a loan transaction, the husband of the complainant, my lord, he is the agent, my lord. He promised me, petitioner number 1, my lord, to provide a loan, my lord. So, my lord, even loan was arranged, my lord, 1,75,000 credited in my account. He asked me to transfer the amount to the to him, my lord. So I have transferred that amount, my lord. Out of that, my lord, he has cheated. So a case, counter case has been registered by me for cheating, my lord. There was the amicable settlement of the issue, my lord. Despite that, my lord, this case has been registered, my lord. Here is the
Submit that there was a commercial transaction between the parties and they have been falsely implicated. They pray for bail. Learned lawyer for they pray for anticipatory bail. Learned lawyer for the state oppose the prayer. We have considered the materials on record. There was a commercial transaction between the parties. Injuries are not grievous. Under such circumstances, we are of the opinion custodial charge investigation is complete. Under such circumstances, we are inclined to grant answer.
Grateful, my lords.
Well, I'm for the petition. Rule section 307 along with 2527 Arms Act, my lord. Kindly see, my lord, role attributed by the petitioner.
This petitioner before your lordship, my lord, he was there. 2 eyewitnesses are there, and there is a statement of the injured also. Page 8 and 9 is the eyewitnesses, and page 43 is the injured statement, my lord. The very preliminary stage of investigation, 1 person was arrested. He was in custody for 1 month. After that, he was been released on bail from the lower court. 5 person has appeared before the lower court for pre-arrest bail, my lord. Those are rejected, my lord. And this petitioner before your lordship is the first one who has come.
Milan Sek before your lord.
Milan's name will transfer from the eyewitness statement at page 8 and 9, and even the injured, my lord, his statement at page 43.
Considered the materials on record. Petitioner was a statement of witnesses as well as that of statement of the injured and other witnesses show petitioner was a member of a group who fired at the victim. As a result, he suffered gunshot injury. Under such circumstances, we are not inclined to grant answer.
I'm deeply
Next.
My lord.
32.
My lord, due to the illness of the mother of the learned advocate, my lord, he is not come court. Only 1 day accommodation. Not today.
33. My lord, I am for the petition. My lord, co-accused statement. My lord, from below commercial, from on Sofikul Sek. On his statement, our name was implicated.
Charge sheet file.
Charge sheet file.
Charge sheet file, my lord, they are habitually into this trade, man,
Alright,
NDPS. man.
petitioner
The report is
is
there.
petitioner submits no narcotics was recovered from his possession. He prays for unsuitable. Petitioner, learned lawyer for the state submit. Petitioner has criminal antecedents. We have considered the materials on record. No narcotics was recovered from his possessions. His complicity has transpired from statement of co-accused, which is inadmissible in evidence. Investigation is complete. Under such circumstances, we are inclined to grant answer. Next.
34.
My lord, for the petitioner. My lord, petitioners are in custody for 1 year, 6 months, 10 days. 15 witnesses are there. Till date, no one examined. my lord.
My lord, after framing of charge, one schedule has been failed, and next schedule they filed this bail application. So case ready is here. That is why no witness movement has been.
Fine.
My lord, on
You
that,
are getting photocopy of a case file.
my lord, what happened, my lord? Bail file.
Petitioner is in custody for 1 year, 6 months. He submits there is delay in trial. He prays for bail, and a lawyer for the state opposes the bail prayer. We have considered the materials on record. Though 54. What is the quantity?
3,000
My lord,
bottle of
3,000 bottles of fancy.
We have considered materials on record. 3,000 bottles of fentanyl syrup was being transported. Trial is in progress. Transported. Petitioner was present at the place of recovery. Trial is in progress. Keeping in mind these facts and statutory restriction at 37, we are not inclined to grant bail. We request the trial court to trial is in progress and one witness has been examined.
No one examined.
charge frame.
Only charge.
Charge has been framed and date has been fixed for recording evidence. Under such circumstances, we request the trial court to take necessary steps to fix schedules at short intervals and conclude the trial within 1 year from the next date fixed for recording evidence without granting unnecessary consent.
Oblige me. Deeply oblige.
Next.
Petitioner is renewing his prayer for bail, my lord. The petitioner is in custody for 2 years and 8 months. My lord, only
2 years,
6,
8 months.
8 months. 6 witnesses out of 11 has been examined. Previously, there was a direction.
Petitioner is in custody for 2 years, 8 months. There is delay in trial. He renews his bail prayer. Learned lawyer for the state.
270 grams of methamphetamine tablets.
Trial is in progress. We have considered the materials on record. Though 270 grams of methamphetamine tablet was recovered from the petitioner, he is in custody for a considerable period. Only how many witnesses examined?
6 out of 11. 6 witnesses.
6 out of
11 witnesses.
11 witnesses have been examined. There is no possibility of trial concluding in near future or delay in trial. Allowed.
Gratefully.
Next.
My lord, I am not pressing the matter.
Not pressed, dismissed. Next.
My
lord, I am for the petitioner. My lord, petitioner is custody for 5 years, 3 months. More than 5 years, 3 months. My lord, out of 7 witnesses, only 3 witnesses have been examined, my lord.
Petitioner is in custody for 5 years and 3 months. He submits there is inordinate delay in trial. Prays for bail. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Though commercial narcotics have a commercial quantity. What was recovered?
10 liters of codeine mixture.
That is 10 liters of codeine mixture was recovered. Petitioner is in custody for considerable period. Only 3 out of 6 witnesses have been examined. There is no possibility of trial concluded in near future. So answer. Next.
38. My lord, I'm appearing for the petitioner, my lord.
My lord, in custody for my lord 3 years 82 days. My lord, there was a recovery of 375 gram of yoga tablets. My lord, out of 7, my lord, only 2 witnesses have been accepted.
My lord, kindly have a look, my lord, the last order of rejection, my lord.
We have
My lord, last order of rejection, my lord. That my lord, delay was on the ground that my lord, he could not, my lord,
correct,
set up
correct,
the lawyers,
correct.
my lord.
Now,
And my lord, so far as the
we want a report from you.
my lord.
Petitioner is in custody for more than 3 years. He renews his prayer for bail on the ground of delay in trial. A learned lawyer for NCB shall submit status report with regard to the stage of the proceeding and the reason for delay. Matter will appear when?
My lord, 15th or 14th, 14th or 15th subject to lordship's court.
15th Chuti, 14th.
14th
Chuti.
Oh,
14th.
then 14th, my lord.
Next.
Okay, I'm for the bill. That's 97 bottle of fentanyl. Petitioner is the custody 2 years, 2 months, 15
2
days.
years, 4 months. When?
2000 December 23.
Then any direction?
No, my lord.
Petitioner is in custody for 2 years, 4 months.
2 years, 2 months, 15 days.
2 years, 2 months. He prays for bail on the ground of delay. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. What is the stage of the proceeding?
My lord, warrant issue against the witness. Can you see the last order?
We have considered the materials on record, though allegations involve smuggling across international border. Prosecution appears to be very indifferent and has not produced its witnesses. Witness warrant was issued. In this backdrop, we are constrained to hold. There is little possibility of trial concluding in near future, and petitioner has made out a case for bail on the ground of delay in trial. So and so. Delay is not restricted. Allowed. Next.
My lord, as for the petitioner. My lord, petitioner is in custody for 1 year, 8 months, 26 days. Out of 7 witnesses, 4 have been examined, my lord. My lord, 1 year, 8 months, 20, almost 1 year, 9 months, my lord, in custody. My lord, recovery is 286 grams of
6
heroin.
months, 6 months. It will
Well,
complete.
next date are fixed for examination. It's on 3rd January 2025.
Correct. Where petitioner is in custody for 1 year, 8 months. He pays for bail on the ground of delay. Learned lawyer for the state submit. The trial has substantially progressed. We have considered the materials on record. 4 out of 7 witnesses have been examined. Next schedule has been fixed in January 2025 for examination of remaining witnesses. Under such circumstances and as in this background and as recovery of narcotics is above commercial quantity, that is 286 grams of brown sugar, attracting restrictions under 37 of NDPS Act, we are not inclined to grant bail. We request the trial court to conclude the trial at an early date without unnecessary. Next.
41. Lordship, nothing has been recovered from an Arms Act case. Petitioner was shown arrested in this case.
No narcotics was recovered from his possession. He has been falsely implicated. He prays for bail, and a lawyer states that petitioner has criminal antecedent. We have considered the materials on record. Statement of witness, co-accused statement. Co-accused statement allowed.
Great. Special court NDPS.
Next.
No seizure from this petitioner. His implication is from the co-accused statement. 100 days in custody.
110 days in custody. 100 days in custody. No recovery. Co-accused statement allowed. Next.
Next is also same co-accused statement. In this case, some of the co-accused was granted anticipatory bail.
No, my lord.
And some of the co-accused on bail.
Maybe.
My lord, this petitioner was absconding for a considerable period of time. He was arrested on 21st of August 2024. My lord, from the CDR, it shows that 37 calls and 51 calls was made by and between this petitioner and the principal accused who was arrested.
79 days.
Petitioner is in custody for
79 days.
79 days. He submits. No narcotics was recovered from his possession. Co-accused are on bail. He prays for bail. Learned lawyer for the state submit petitioner had absconded. CDRs show telephonic conversation between him and the co-accused from whom narcotics was recovered. We have considered the materials on record. No narcotics was recovered from the petitioner. CDRs show telephonic conversation between petitioner and co-accused from whom narcotics was recovered. However, contents of conversation are not known. Co-accused are on bail in view of this. In view of the aforesaid facts and the slender evidence connecting the petitioner with the alleged crime, we are of the opinion he has been able to rebut statutory restriction at 37 of NDPS Act and may be enlarged on bail. Next.
Grateful.
44.
My lord, I am not pressing the matter.
Not pressed, dismissed.
Lordship, on 9th of April, your lordship rejected the co-accused prayer with when assurance was given by the state that they will take from step for expedite the trial. Now, lordship, prior to that, charges was framed at page 13. You should get that order. Now, lordship, thereafter 3 dates, 29, 30, and 31st of July. Date
How long
fixed
you
for
are in custody?
more than 2 years. For last 3 dates, there is no witness present.
No witness conduct, your lordship. Next date is fixed on
20th November.
2020.
And
2
from
years and
2
1 month. 34.99 kg ganja has been recovered.
from 2%.
Charge has been framed there.
Prior to that, charge frame on March 15.
Prior to
Okay.
rejection.
And thereafter, no date was fixed.
No date was fixed, your lordship, but the witness did not turn up, your lordship.
How many scheduled?
One schedule, 3 dates.
3 dates.
Only one
Next is
schedule.
fixed on November.
Huh?
Next is fixed on November. 20th November.
Let us see November schedule.
Your
Thereafter.
lordship, kindly adjourn this matter. 22nd
Why
November.
adjourn? You withdraw and file afresh.
Plus.
Not pressed. Next.
Lordship, can it be one line added as the next date is?
Petitioner prays for bail on the ground of delay. Renews his prayer for bail on the ground of delay.
No, first application. Co-accused pair was rejected by you.
Petitioner prays for bail on the ground of delay. We note that the schedule for examination of witnesses have been fixed in November 2024. Prosecution assures that witnesses shall be examined in the said schedule. In light of the assurance, petitioner withdraws the application.
Great.
Next.
46.
Order for the petition. The case of no recovery on the basis of co-accused statement, my name transferred. I'm in custody for 94 days.
Yes.
Well, this is a very initial stage of investigation. Charge sheet has not yet been submitted. This
How
present
long he is in custody?
Lord, he is in custody for Lord, 3 months. My lord,
That is
may I-
initial.
my lord, may I say
Petitioner is in custody for 90 days. No narcotics recovered. He prays for bail. And a lawyer for the state opposes the prayer. Statement of co-accused allowed. Next.
At 47, I'm for the petitioner, my lord. 21A, 21C, 29, my lord. 14A, 14C, Foreigners Act, my lord. I'm in custody, my lord, 4 years, 4 months, my lord. Till date, no witness has been examined. my
Well,
lord.
only one has been
I'm paying
examined
bill on
on
the ground
10th
daily.
of September. Next date is on 3rd, 4th, and 6th of January.
Hmm.
But my lord, he is a Bangladeshi national. The entire contraband was recovered from him.
Petitioner is in custody for more than 4 years. He is Bangladesh. How long will you take to conclude?
My lord, admittedly, I find that earlier on 5 occasions, prosecution witnesses did not turn up.
Why?
That explanation.
Huh?
May I get a report, my lord?
This is a Bangladeshi who is carrying narcotics. This is the conduct of your prosecution. Shocking. Shocking. Petitioner is a Bangladeshi national. He is in custody for more than 4 years. He prays for bail on the ground of delay. We take note of the fact that the offense the offense of drug trafficking is conducted by a foreign national. However, prosecution is indifferent to the gravity of the offense and has not taken steps to conduct trial in an is indifferent to the gravity of the offense and has not taken steps to conduct trial in a prompt manner. Superintendent of Police Malda is directed to submit report with regard to the reason why prosecution is being conducted in a lackadaisical manner and propose a time frame within which the same shall be concluded. Matter will appear on 14th.
Great.
48, I'm for the petitioner. My 2 years, 3 months, I am in custody, my lord. My out witness examined. My lord, next date in 26th of November 2020.
Petitioner is in custody for 2
Out of 12 months in examined.
12.
8. I am adding the all orders.
The last date is on 28.
Who will prosecute you? You will prosecute yourself.
No.
Then he is saying 12, you are saying it.
The last date is on 28.
Then it's ever at the verge end. Petitioner is in custody for over 2 years. He prays for bail on the ground of delay. Learned lawyer for the state submit. Trial has substantially progressed. Most of the prosecution witnesses have already been examined. We have considered the materials on record. 580 bottles of phencyl syrup containing codeine phosphate was recovered from petitioner. Trial has considerably progressed. There is no 12 out of 13 witnesses have been examined under such circumstances, and in view of statutory restriction 37 of ADPS Act, we are neither inclined to grant bail on we are not inclined to grant bail either on merits or on the score of delay. Trial court is requested to conclude the trial at an early time. Next.
My lord, 49. 49. My lord, 49, my lord, we are in custody for 1 year, 5 months, 23 days. Total 62 days. 15 July charge has been paid. Till date, no trial has been started.
What is the quantity of
My
narcotics?
lord, 80 kgs.
80 kgs of ganja.
80 kg. From joint possession. Not a single witness has been. My lord.
How many witnesses are there?
But next
Total
date is
16.
fixed on 26, 27.
We are giving 1 year time for them to conclude the trial. Petitioner is in custody for 1 year, 5 months. He prays for bail on the ground of delay. Learned lawyer for the state submit. Charge has been framed. Date has been fixed for recording evidence. We have considered the materials on record. 80 kgs of ganja. Statement of witness and contemporaneous document that the Caesar memorandum show recovery of 80 kgs of ganja from petitioner and co-accused. Date has been fixed for recording evidence. Prosecution assures that the trial shall be concluded within a year. Under such circumstances, and in view of statutory restriction on 37 of NDPS Act, we are not inclined to grant bail. We request the trial court to conduct the trial with utmost expedition in light of the assurance given by the prosecution and conclude the same at an early date without granting unnecessary adjournments. Next.
And at liberty to communicate this order.
Great.
Next.
50. My lord, I am for the petitioner. My lord, the petitioner was released on bail on 3rd of September 2014. My lord, 200 grams of heroin was recovered from joint possession. My lord,
Then you ran away.
My lord, after COVID, my lord, on number of occasions, the petitioner did not appear. My lord, warrant of arrest was issued.
Get a death certificate?
My lord?
You couldn't get a death certificate?
My lord, warrant of arrest was issued on 20th.
We appreciate everything. When will you conclude the trial?
Lord, it is at the end.
3:30, it was fixed.
Then 3:30.
At the stage of 3:30.
Petitioner had please. Petitioner had was on bail earlier. He absconded. Presently, the trial is at its fag end. Under such circumstances, we are not inclined to grant bail. We request the trial court to conclude the proceeding at an early date.
Grateful.
ডেথ সার্টিফিকেট দেখাচ্ছেন
No.
আপনার ডেথ সার্টিফিকেট আপনি লাইক
My lord, I am for the petition.
ভোটার কার্ড এবং আইডেন্টিটি
My lord, I am for the state. My lord, I am led by Mrs. Shubhasri Patel. My lord, she is ill. My lord, brief and CD is not with
when
me.
will she recover? Tuesday. Shubhasri Patel. All right. When do you want? Tomorrow? Monday?
Monday.
Monday. Is my June.
এমনি দিয়ে দাও হ্যাঁ 52 50 I'm opposing this
Yes, Mr.
Item 52, I am for the petitioner, my lord.
Good.
Recovery of 4 kg 354 grams of ganja, my lord. The petitioner is in custody for 74 days. Charge sheet has not been submitted, my lord.
Right. On 20
Prosecution report filed.
Yes,
Very
23rd
good.
October complaint.
Petitioner contents narcotic, the amount of narcotic recovered is below commercial quantity.
No, it is above commercial. 4.5.
Ganja
4.5.
How much?
Ganja.
How much is the what was recovered?
My lord, 4 kg 354 gram of ganja. 20 kg is the commercial, my lord.
My lord.
People are thinking of
I saw 40.
Decriminalizing marijuana.
I saw 40.
Is below commercial quantity. Investigation is completely praised for bail. Learned lawyer for customs opposed the bail prayer. We have considered the materials on record. Amount of narcotics recovered is
354 gram.
4.354 kgs of ganja, which is below commercial quantity. Prosecution report has already been filed. Under such circumstances, we are inclined to grant bail subject to conditions. While petitioner, while on bail, shall remain within North 24 Parganas, South 24 Parganas, or Calcutta, and provide the address where he shall reside to the investigating agency and court report and court below, and report to give the investigating officer's name to so and so once in a week until further orders.
Grateful, madam. Grateful.
People, Mr. Kundalia, give the name. Yes, next matter.
I'll give it. No. I'll give the customs officer's name.
53. Thus, I am for the. Thus, I am claiming parity. 6 November, 2 co-accused have been granted.
Parity.
The order is not available, but my lord, delay is at 2 years, 8 months.
Where is the order?
It has not been uploaded, but the
So let
status
us
is
see
showing
the
is
order. E-court of Tuesday.
Monday.
Next.
Tuesday. 54.
Lordship, 2 of the co-accused persons were granted bail.
Only difficulty is page 11.
Lordship, mine is renewal. 2 of the co-accused persons were granted bail by your lordship. 2 years, 9 months, I am in custody.
All right.
11 is the difficulty. Thereafter, his prayer for bail was turned down by this honorable court, and direction was given for 1 year.
But
That has not elapsed as yet.
But lordship, I am on the same footing.
Who has been granted bail?
The others were granted bail.
Sheikh Azad.
After he came, his prayer was turned down by this honorable
Can't
court.
help it. Regular bench. Regular bench.
Regular bench.
Regular bench rejected.
Rejected.
Next.
55.
For the
55 minute time is not suitable on Monday.
By Monday. Why Monday?
He is asking.
Not suitable.
He has taken trouble to come.
He has other matter.
Yeah, not today. After we come after 5. Yes.
My lord, item number 56.
My lord, I am for the appellate.
Before my learned friend starts, my lord, it should go before the regular bench. It was appearing before this lordship since 27 July 2024.
Well, that
And it was
determination
heard
is
along
with your
with
lordships now,
Manoj
subject to
Ghosh.
correction.
Regular bench.
And your lordships have earlier dealt with this matter, rejected my. Very well, very well. Very well. My lord.
Why you? How long are you in custody?
My lord, 1 year, 3 months, and it is that matter where from me only an air gun was recovered.
So what?
And they said in January when your lordships rejected, they said they are conducting a further investigation after filing 3 charge sheets. My lord, even today that further investigation is going on.
The regular bench considered it, Mr. Chatterjee.
My lord, only one thing, my lord, subject to correction by your lordships. My lord, perhaps the regular bench doesn't have the determination to take up appeals. Because
bail appeal in the nature of bail application goes to the regular.
that is not there in the, my lord,
determination. Make that submission before the regular bench.
Deeply.
57. My lord, I am for the petition. My lord, principal accused person has been granted bail on 5th of November. I am standing on the same footing. My lord, I am in custody for 9 months.
If he is principal, how can you stand on the same?
The texture of the case is that the victim died due to a road traffic accident.
All right.
And he was.
Petitioner submits that the victim died due to an accident. He has been falsely implicated. Co-accused has been enlarged on bail. He prays for bail and a lawyer opposes the bail prayer. We have considered the materials on record. Victim appears to have died in a road traffic. Victim appears to have suffered injuries in an accident and died on 28/12/2023. Under such circumstances, Gopal Sarkar has been granted bail. Petitioner is entitled to similar relief.
I'm grateful to you.
Next.
58.
No, 58 I am for.
58 minute, may I just bring a record? Charge was framed on 30/2/2022. After that, how many adjustments?
Out of 34, 5 have been examined.
How long you are in custody?
My lord, 3 years, 124 days.
Let it go to regular weeks.
My lord, last seen, my lord.
Circumstantial evidence. Wednesday. Petitioner is in custody for over 3 years. He submits there is delay in trial. He prays for bail. State shall submit report with regard to status of proceeding and the ground for delay. Adjourned Wednesday. Next.
59.
Please, your lord.
What?
All right, co-accused have been granted bail.
Co-accused have been granted bail.
6th of November. Rampada Singh.
Where is the order? Order!
I have annexed.
Where have you annexed?
Last page, my lord. 22nd of August.
Where last page? Where last page? Not today.
61.
Well, for the petitioner, allegation is that there's a long-term family dispute between the de facto complainant's family and the petitioner's family. And in connection with the present case, other co-accused has been granted bail and anticipatory bail by this honorable court, my lord.
Your Lordship, I am de facto complainant. I am led by Mr. Dhruv Surana.
Malad, I'm appearing online, Malad, for the de facto. Malad, two persons granted bail, Malad, one on parity. Malad, both orders have been challenged in the Supreme Court, and notice has been issued, Malad, returnable on 3rd of December. And Malad, as a complainant, Malad, I have not been supplied with a copy of the bail application. Malad, in case if I am supplied, Malad, I'll be opposing the prayer for bail.
What?
Malad, I have not been supplied with a copy of the bail application. Malad, in view of Jagjit Singh's judgment, Malad, the victim has a right to be heard, Malad, in case the offence is above 7 years. Malad, my associate will hand over the copy of the Supreme Court order as well as the orders passed by the coordinate bench.
Correct.
Your Lordship, kindly see para 14.1, page 18 to 26.
Copy of the petition we given. We keep this on Monday. Monday we are keeping it.
Very well, Malad, I'll be there. I'm deeply obliged.
We'll enlarge them on interim bail, awaiting your Supreme Court result.
Very well, Malad. Very grateful.
Time for the state. That I am appointed by legal aid Miller to move this application. Miller, this petitioner is one of the 30 terminally ill persons.
Terminally, same order. In the report, একটা হলো না terminally petitioner is suffering from serious illness. He prays for bail and a lawyer produces the case diary. In the report filed before this court in so and so, the petitioner is named as one of the terminally ill under trial prisoners in view of the aforesaid fact. And as there is no chance of trial concluding in near future, we are inclined to enlarge the petition.
Deeply obliged. Well, hello. He report দিতে বললো না?
দেখো, ঠিক আছে। AKD. Next.
63.
Malad, I am
For the de facto complaint, Your Lordship.
Malad, 290.
Not today, my lord. Case diary not
lord.
received, my.
Not there. Case diary
I am
not there Monday.
My lord,
Yes.
my lord.
হ্যাঁ আমাদের তো 66
66
No, sir, I am for the petitioner. This is that case where petitioner is in custody for 8 years,
My lord,
but
yesterday, my lord has asked me regarding, I have told you, your lordship, that in Agradar case, he has been convicted. He has been convicted in 2038, 2019 for a period of 8 years.
8 years.
8 years.
So he's continuing, no?
no, he was arrested in connection with that case on 30th of October 2016 and sentenced for 8 years under 16 and 20 of the UAP.
Sentence was on 38, 2019.
Date of
So what, the
arrest.
remission he will be getting since he was arrested in 2016. So apart from that remission and
So 16 to 24 is 8 years completed. So here he is not at all in custody.
No, subject to correction. I was first arrested in this case. Thereafter, I was shown arrested in that case. Now, lordship, subject to correction. If after conclusion of trial, if at all I convicted in this case, then under 427, subject to correction, lordship, if I make an application for concurrent running of both the sentences, then in that event, I am in custody for 8 years.
Concurrent running in a subsequent case. This is a prior case, isn't it?
No, this is a prior conviction, but this case is first case and the NIA case is the second case.
Code 67 BNSS now.
Lordship.
427, the provided part. Is 120 there also.
Code 67 1. So when his subsequent conviction he may be given concurrent running or consecutive running. So it is unclear whether this entire period is. When were you arrested in this case?
In this case, I was arrested on.
So it is unclear whether your 8 years will be considered as an under trial detention.
Arrested 25th of September 2016. Now, Lordship, subject to correction, I have gone through few judgment of the Apex Court.
Apex Court judgments are not in 121A. We have passed a judgment. Perhaps you were appearing in that matter. We have ourselves passed an order.
In all the judgments, ultimately Supreme Court pass an order with a concurrent.
Correct. What are those cases? They are all of theft, cheating.
Even
One is of
NDPS.
Justice Lalit's judgment.
Even NDPS also.
Then, yes. And then you have Justice Chandrachud's judgment. So we have ourselves referred to all those judgments and passed. It depends on the nature of the case.
Nature of the case. Now, Lordship, if your Lordship see this case, apart from co-accused statement, there is no material against me, and only Lordship subject to correction, there is a judgment of the Apex Lordship knows that a member of an unlawful assembly doesn't implicate me as an accused in connection with any case. Means unauthorized banned organization.
Membership will, and you are a Foreigners Act also.
No. Foreigners Act not against me, against others.
All right. Petitioner is in custody for more than 8 years. He submits that there is no possibility of trial concluding in near future. He prays for bail. Learned lawyer for the state contends petitioner had been convicted in another case and was sentenced to 8 years imprisonment. The period of imprisonment under such period of imprisonment, the period of imprisonment awarded, period of sentence awarded in the previous conviction has come to an end, and he is entitled to concurrent running of the sentence with the said period, in the event he is convicted in the present case under in view of section 467 CRPC, 467 BNSS. We have considered the materials on record. Allegations in the case. Allegations are very serious and relate to the membership of the petitioner in a banned organization, However, no overt act is attributed to the petitioner, and his crime to the other offences and his complicity to the offences is primarily based on statement of co-accused, uncorroborated statement of co-accused. Petitioner has already served out the sentence awarded in terms of in the earlier case. In another case, and is entitled to seek concurrent running of sentence even if he is convicted, concurrent running of the two terms, even if he is two terms of the terms of imprisonment, even if he is convicted in the present case, as per section 467 BNSS. Under such circumstances, we are of the opinion there is no possibility of the trial concluding in near future. Under such circumstances, we are of the opinion further detention of the petitioner would infract his right to speedy trial under Article 21 of the Constitution of India, and he is entitled to bail on this score. 10,000 to sureties petitioner while on bail shall remain within
Kolkata.
within Kolkata,
Calcutta and
within the district of Calcutta and South 24 Parganas, provide the address where he shall, except for attending court proceedings, is where the case is? Calcutta.
Vichar Bhavan.
All right. Ota court proceedings, no? And report or address, etc.
Report, Malat.
Report once in a week to your officer.
Grateful, Your Worship.
Officer in charge, STF.
TJM Calcutta.
Remember, one more request, the petitioner should provide his phone numbers also, which he will be using.
The mobile numbers of the petitioner shall also be provided to the investigating agency.
Grateful.
Officer in charge. Next.
68. 68, not today. Just now I have this.
Not today.
Grateful.
69.
For the petition, it's the Foreigners Act matter, Millet. It's a Foreigners Act matter, Millet. The pursuant to Lordship's direction, they have supplied
that matter.
That matter. Millet, the
Let us see why you have said that it is false.
And page 82.
Your ration card is false.
The ration card issue was that there was a difficulty regarding the name, which has been subsequently clarified pursuant to an order passed by the learned SCJM that the person Milan Gaji and the Milan Farji and Ruma Khatun and Roma Milan are the same and identical person. That report has been submitted by the investigating officer himself. If your Lordship kindly sees page 16 of my application.
All right.
And the voter card is still existing, Miller, on the record. Today I have.
See page 82, Miller, regarding voter card. Awareness scam, it was issued.
This was a, have you seen this? How it was granted? How this voter ID card will be granted like this?
This was granted, but thereafter no step has been taken to cancel this.
Whatever. See, Mr.
But I have seen that.
What is this?
In a
How
awareness
can it?
scam-
First, Aadhaar, no proof of citizenship. Secondly, just in the voter awareness scam, someone says, I reside here, voter ID card is granted. Is the BDO empowered to do that?
But subject to correction, that if your Lordship kindly direct for a field inquiry from the residents of that place who are there residing over there.
We have seen.
Because this
we have
report was
considered the
submitted
materials
when I
on
was in
record.
custody.
Report shows that the voter's identity card was granted in an illegal and irregular manner. In view of the aforesaid, we are not inclined to grant bail to the petitioner at this stage. Next.
Wishing Shubh Vijaya to your lordships first.
Yes, yes, thank you.
Lordship, now, Millard, I'm cutting a sorry figure for today, Millard. Millard, can I get an accommodation, Millard? Because I'm totally handicapped as far as today. I've got a report which is neither here nor there.
All
Millard, if any day, Millard, pursuant to Millard, next week, Millard.
How long you are in custody?
For more than 3 years.
More
Millard,
than
this post-poll matters, but now, Millard, since the trial has again begun, Millard, what little I could understand from a snapshot report.
Page 16, my application.
we have seen.
Thereafter,
All right, Wednesday.
I'm
Wednesday,
grateful.
report be filed.
I'm grateful.
CBI shall submit report with regard to status of trial and the role of the petitioner vis-a-vis co-accused who are on bail.
I'm
If they are on similar footing, Mr.
No, Millard, here, this person, what I could read is that, Millard, he is the person who had hurled the bomb on the victim, and he has been identified by 4 of the witnesses. 12 witnesses have already been examined. 18th is the next date.
But others are on bail. Just
Well,
make it
on the same footing or not, that I will assist
please
my lord.
ascertain.
I'll assist
We have not asked you anything. Next.
Millard, I'm grateful.
72. So I'm for the petition.
I'm for the state, my lord.
My lord, petitioner is the father of the deceased. Complainant is the daughter of the deceased. My lord, principal accused got bail. I am custody for 106 days. Charge sheet submitted, my lord.
And I would kindly peruse this 164 statement.
And
My lord,
Jakir
there are
Mal got
statements
bail, my
that
lord.
the father and the son were regularly involved in drunken brawls. This is one
When father assaulted,
father assaulted.
petitioner is in custody for
61 days, my lord.
61 days. Principal accused is in bail.
My lord.
And
Further
he has
details.
been discharged.
And this-
Principal accused has been discharged, my lord.
Why?
My lord, the principal accused, all the statements, they do not implicate the principal accused.
Then?
Eventually, it comes down to the father only. And
Why father?
my lord, the last scene, there is only one eyewitness who says that he saw the father assaulting the son, both in drunken conditions.
And kindly see the FIR, my lord.
And the confessional statement of the father is also there, my lord.
So this petitioner is the father.
Father, my lord.
So he is the principal accused. Then.
Now he's the principal accused.
No, my lord. Principal accused, FIR name accused, my name is not mentioned in the FIR. My lord.
This petitioner's name is not mentioned in the FIR. The FIR named accused has been discharged, my lord.
Discharge.
Chachi Nagar.
Kindly consider, my lord.
Statement of Asha Bibi was taken.
Statement of Asha was taken, my lord.
Where is Asha's
It is page number. Page number 56, my lord. She has taken a different stand, my lord. She didn't say much. But there are other statements, my lord, which attest to the fact that they were involved in regular brawls, drunken brawls, my lord.
Correct. So who is this Johiruddin Mal?
Zahiruddin is the one who was the FIR named accused person, my lord. He was involved in a fight the previous night. So the night before the incident,
আজ 12/4/2024 জহিরুদ্দিন মাল বাড়ি থেকে ডেকে নিয়ে যায়।
My lord.
তখন আমরা কিছু যে পরে 2টো নাগাদ
আমি বাড়ির পিছনে পুকুর ঘাটে গেলে
বাড়ির পেছনে পুকুর ঘাটে গেলে দেখতে পাই দাদা মাটিতে পড়ে আছে।
My lord.
So and so.
My lord.
Where the dead body was recovered?
From around the house of, it was adjacent to a pond in the locality, my lord.
Huh?
Adjacent to a pond in the locality.
What?
Adjacent,
How how is Johiruddin Mal discharged? What, my lord?
my lord, even a
You are a
bamboo stick
lawyer
was
of the
recovered
state.
from.
If you see, are you next time someone will say cow jumped over the moon, and he will say, my lord, police has said. Is this the role of a public prosecutor? The entire fulcrum of criminal justice system rests on you. You are the conscience of the state. Your Johiruddin, if your police officer is believed to be honest, made a confessional statement to the police.
The offending weapon was also.
The FIR maker says that last scene was with Johiruddin. Then you get someone to say that the FIR maker said that this was the responsibility of the father. We're going to release him on bail, but we want the explanation of the investigating officer why he discharged Johiruddin. Petitioner is the father of the deceased. He submits he has been falsely implicated. He prays for bail. Learned lawyer for the state submit. De facto complainant stated, submit one of the witnesses stated before magistrate that the de facto that he saw the de facto complainant chastise his father, that is the petitioner, as to why he had committed the act. We have considered the materials on record. Statement in the FIR, the de facto complainant implicated one Johiruddin Mia in the Johiruddin Mia, na?
Mal.
Mal in the crime. Full stop. It is strange. In such view of it is strange why her version in the first information report runs counter to the statement of the witness before magistrate that he heard the complainant make the petitioner responsible, accuse the petitioner of the murder. Full stop. It is equally, the situation is rendered murkier by the evasive conduct of the de facto complainant in refusing to make statement before magistrate. In this backdrop, investigating agency discharged Johiruddin Mal and implicated the petitioner in the charge sheet. We call upon the investigating officer to explain why Johiruddin Mal was discharged from the case. The slender and inconsistent evidence against the petitioner is not convincing. Accordingly, we enlarge him on interim bail. Interim bail of 10,000 to sureties. Matter will appear 2 weeks hence, and report be filed on that. Next.
May please tell us. The allegation 302 and other section. Charge sheet have been submitted. I am in also custody 168 days. Who are accused? Subrato Maiti has been granted bail.
How is it 21? What happened to 21 accused persons? Similar case, we have granted bail.
Yes,
Yes, on
but
6th.
order sheet I have not received.
All right, we'll get the order sheet Tuesday. This pick and choose business will not do, sir. 41 accused, 20 charge sheeted, 21 discharged. Why? Right. Next.
Order sheet আপনি তাহলে নিয়ে আসবেন তাহলে আমাদের কেস নাম্বারটা নিয়ে এই order sheetটা নিয়ে আসবেন স্যার
74 for the petition, my lord. I'm claiming parity, my lord. For several
He
accused
claims parity.
My lord, so far as involvement is concerned, similarly placed, but the duration, my lord, is comparatively much less.
No, my lord. A day before yesterday, your lordship has been granted bail to another co-accused.
144 days.
144 days. I mean
3 months.
110 days.
So 144.
No.
And the others
You
are more
know-
than 1 year.
Arithmetic, you know. 144 and 110 is same.
Not same, my lord.
Regular bench.
But not same, my lord. Well, other co-accused who has
Regular bench. Every day reduction. Next, you will come with 60 days.
copy-টা দিবি order copy-টা
Next.
I'm for the petition.
75 302.
I am opposing
This is misbehave with the wife of one Biplab Dev Sharma. There was an altercation and that Biplab Dev Sharma stabbed him, resulting in his death. Present petitioner is the uncle of that Biplab Dev Sharma. 331 days.
Eyewitness,
custody.
he hold the victim and the another accused who is in custody stabbed.
331 days, not principal accused.
Evidence, an eyewitness may be complete because Tuesday and Wednesday is the date for
Evidence is going on. Witness action is going
Let me come back on next Friday.
on. Forward. Don't
Let
press the
the-
application. Let the evidence
not
be
pressed on
recorded.
April event.
Then you move the application.
Absolutely.
Let us see what is. All right, Mr.
The trial has already started.
So what? That doesn't stop us from giving bail. Later you go and depose. That's all.
Two witnesses have already examined.
Correct.
11.
Let them be deposed. As of now, bail application is not pressed. Trial is in progress. Under such circumstances, petitioner chooses not to withdraw the application. Application is dismissed as not pressed.
Grateful to you. Deeply.
Okay, thank you.
Yes, Arindam Jana.
My lord,
My lord,
I am in
I'm being led by Mr. Debashish.
Led by?
Debashish Roy.
So?
and I am renewing my prayer for bail. My prayer was rejected in the month of February, page 7. My lord, thereafter, my lord, similarly circumstances, other persons, they
All
have
right.
been granted bail.
Petitioner is in
My lord,
custody
page
for
9, 1 year, 2 months.
1 year, 2 months. Co-accused has been granted bail. He stands on the same footing.
No, my lord, he's not on the same footing. My lord, he's one of the conspirators of the entire event.
Huh?
Because one of the co-conspirators of the entire event. It's a gang-related matter, my lord.
He is a. All right. One co-accused is on bail. There is little possibility of trial concluding in near future. Offences, even if proved, would not attract mandatory life imprisonment. Accordingly, we are inclined to grant bail. Next. Yes.
77. Same footing, but only difference is this petition are granted.
Cannot be same footing.
My lord.
See your opposition.
1 year, 20 days, but I am in custody.
My lord, he is absconding for 3 years. It's a organized racket.
How long are you in custody?
5 months. Near about 5 years.
5 months. And others were granted bail?
After 1 year.
1 year.
My lord, he has absconded and my lord, the other person got bail due to the absconsion of this petitioner.
Petitioner is in custody for 5 months. He prays for bail on a lawyer for the state submit co-accused is on bail, he prays for bail. Learned lawyer for the state submit, petitioner absconded for a protracted period of time. As a result, the trial was delayed. We have considered the materials on record. Petitioner had absconded for a considerable time. As a consequence, trial was delayed. Hence, we are not inclined to grant bail to him on parity. Next.
Next time for the petitioner, my lord, I am in custody, my lord, 9 years, 6 months. 302.
Only IOS witness evidence is.
As per my instruction.
Petitioner is in custody for 9 years. There is inordinate delay in
He is
trial. He prays
habitual
for bail.
offender.
Learned lawyer for the state submit. Trial has substantially progressed. Only one prosecution witness
Only
is
IO is required.
yet to be examined. We have considered the materials on record. All vulnerable witnesses have been examined. Petitioner is in custody for a protracted period of time. Under such circumstances, we are of the opinion petitioner has made out a case for bail on the ground of inordinate delay in trial and is entitled to be released on bail. 10,002 sureties. Petitioner, while on bail, shall remain within the police station, within the jurisdiction of police station Shantipur, and report to officer in charge Shantipur once
He
in
is
a
notorious criminal in this locality.
All right. 9 years is too long. If there was so much of concern about him, the trial should have been concluded earlier. Yes, Ashok Dasho.
324, 327, 323, and Section 75 of Juvenile Justice Act, my lord.
Then,
but I am in custody for about 160 days.
Oh,
Petitioner is a
de facto is appearing. De facto complainant is appearing. All right, we give him bail. Petitioner is in custody for 160 days. The investigation is complete. Stepfather.
Stepfather. Husband of the
mother.
Expired.
We know.
Thereafter, he got married to this.
Naturally, now you are using the stepson as your domestic help. That is your conduct.
Daughter,
Daughter, just think of it. Petitioner is in custody for 160 days. Investigation is completely praised for bail. Learned lawyer for the state opposes the bail prayer. Learned lawyer for de facto complaint also opposes the bail prayer. We have considered the materials on record. Although conduct of the petitioner is not appreciable, keeping in mind the period of detention and the bleak possibility of trial concluding in near future, we are inclined to grant bail. Allowed. Next.
80.
Correct. Some have been granted bail.
My lord, peruse this order. It's your lordship's order, my lord. Rejection of one of the co-accused who stands on the same footing, and this is my lord has mentioned in that order this present petitioner's name. And
Wahab.
Yes.
We have petitioner to submit that co-accused have been granted bail. He is in custody for over a year. He prays for bail. Learned lawyer for the state submit petitioner bail prayer of one Rokib Khan, who stands on the same footing with the petitioner, was turned down by this court. We have considered the materials on record. We have considered the materials on record. Petitioner made a confessional statement that he had committed the murder. He, in view of the aforesaid incriminating material and gravity of the offense, we are not inclined to grant bail at this stage. Next.
376.
I'm for the deserted by a husband was staying with the parents.
307, my lord. The fact is that, my lord, prior to that, my lord, petitioner filed an application for anticipatory bail. Your lordship has been turned down. Thereafter, my lord, he suppressed the fact and filed an application before the session judge. I'm bullying Dada.
7 years.
Session judge, my lord. Thereafter, my lord, session judge allowed the said application. Thereafter, my lord, de facto complainant filed an application for cancellation. High Court cancelled the bail application. Subsequently, petitioner challenged the said order to the Apex Court, my lord. Same was my affirm, my lord. I am custody for my lord 61 days, my lord.
Stay for some more time.
My lord.
My lord, anticipatory bail.
Nature of injury?
Nature of injury, my lord, I would show to your lordship, my lord. There are injury, many persons have been injured, my lord. My lord, kindly see.
My lord,
Complainant.
I am for the complainant. Only one thing I am
Twice his anticipatory bail was done.
All right, let him. He is now in custody.
My lord, he has undertaken before your lordship in the year 2020 that he would surrender within 15 days.
Very good.
At page, my lord, at page 35, 67.
Simple injury.
67, 72.
And my lord, only one thing.
No.
Pendency of this application. They have again preferred the before the vacation bench for bail.
Very bad.
67, 72.
This urgency has to be taken care of.
My lord,
Pendency of this application
Let
again.
the regular bench consider.
My lord, 61 days.
Your over enthusiasm is to be taken.
And others
For my
are-
client, my lord, tendering my apology. For my client, my lord, tendering apology. My
Go
lord,
to custody for your client. Willing to go to custody for your client. It is because of you. You know, not you personally, but agents and associates around our profession. They are the ones who are responsible for this. The person who is in jail today or who is an accused does not know all these subterfuges. We are the ones who advise. We are the ones who corrupt. So it's actually we who should suffer, and vicariously our client. Regular bench.
Lord, any stringent condition, my lord.
The stringent condition may be rejection. Okay. Next.
83. I am renewing my prayer after 9 months. That allegation under section 306, 304B.
State requesting for a not today.
Not today. Next.
84, my lord, kindly take the matter on Wednesday, my lord, because my lord, the one report is not legible and the injury report of other person is not there.
Original case diary be produced Wednesday.
Great.
It order cost 85 now. I'm happy.
85.
Well, case of 307.
How long you are in custody?
162 days I am in custody.
Nature of injury?
Bullet injury, my lord, and the person, my lord, the petitioner himself has shot that bullet, my lord.
Petitioner is the principal accused. He does not stand on the same petitioner contents. He is in custody for 167 days. Co-accused are on bail. He prays for bail, and a lawyer for the state opposed the bail prayer. We have considered the material on record. Petitioner is the principal accused who shot at the victim. Medical report corroborates. Shows bullet injury and corroborates the prosecution case. Under such circumstances, we are not inclined to grant bail at this stage. Next.
307, 162 days I am.
Use gun, stay. Gun, bomb, stay. Lathi, hashua, we will consider. Village equipment, all right. But imported Munger equipment in custody. Entire Malda Murshidabad. Yes. Birbhum.
No, this is
No.
India.
Now, no, Dia, you are infiltrating. No, Dia.
Well, at 14A,
I have,
I am appearing on behalf of.
my 14A, I have annexed Aadhaar card, voter card, PAN card.
My lord,
All right.
document has already been
Please
sent
give a
for
report.
my lord.
Report petitioner contents he is a Indian citizen. He relies on his voter's ID card and other documents in support of his plea. Report with regard to the authenticity of the documents be placed on record adjourned 2 weeks.
Great. Good. 5/7.
My lord, lab affair.
7. Since there is no designation stamp, lord, the department is not accepted. Kindly give me leave to file the.
All right, leave is granted.
Right. Control. আর বলেনি তো